In terms of their content, many ILO conventions resort to what are referred to as flexibility devices. The basic idea behind them is to make standards flexible enough to be translated into a variety of systems of labor law and of labor relations in countries with different levels of economic development. Flexibility reflects the ILO's search for practical ways to promote universality and convergence in an unequal world. But the flexibility cannot be so extreme as to void standards of their function, which is, after all, to improve labor conditions. As former ILO Director General C. Wilfred Jenks noted, flexibility is not an end in itself. Flexibility devices do not apply to fundamental rights. The idea of flexibility is enshrined in the ILO Constitution, which calls for due regard to be given to countries where climatic conditions, the imperfect development of industrial organization, or other special circumstances suggest that modification may be needed in framing ILO standards. Flexibility can take several forms. The first type of flexibility device involves the nature of the obligation itself. For example, the main requirement of some ILO conventions is merely to adopt a national policy on a specified subject, usually in or after consultation with organizations of employers and of workers. In another example of substantive flexibility, standards on minimum wages do not require member states to set a specified minimum wage. Rather, they call on states to create a system to fix minimum wage rates that are appropriate for a particular country or sector, taking into account the extent of coverage of collective bargaining agreements. Aside from substantive flexibility, a second type of flexibility device permits a ratifying state to limit the scope of its obligation. This can be in relation either to the material scope, i.e. the subject matter, or the personal scope, i.e. the categories of persons or branches of economic activity concerned. Thus, in the field of Social Security, some instruments feature structural flexibility. They permit a state to accept only those parts of a convention that cover some branches of Social Security that the state chooses to designate upon ratification. States may also be able to exclude certain categories of economic activity or specified categories of workers from the scope of the obligation they undertake. This option is used, for instance, when a state would face practical difficulties of a substantial nature in applying all provisions of an instrument to all types of workers. Or, a convention may contain clauses that create exceptions in specified circumstances. Some of the ILO instruments on working time illustrate this type of flexibility. A further type of flexibility is shown by the Convention on Minimum Age for Entering Employment. It contains a provision that is to be temporary. A ratifying state whose economy and administrative facilities are insufficiently developed may initially specify a minimum age that is 1 year less than the minimum age set by the convention. Finally, many ILO conventions offer wide scope as to the means by which ratifying states may implement them, for example, by legislation, collective agreement, court decisions. ILO conventions also often display flexibility in drafting, as expressed in definitions or in use of terms such as appropriate. However, in contrast to other treaties, ILO conventions do not admit reservations. Instruments of ratification that contain them will not be registered by the Director General. It is argued that the flexibility devices make reservations superfluous. Moreover, the conference adopting an ILO convention is composed not only of states, but as well of representatives of employers and workers. They fall outside the traditional state-based regime for registering and objecting to reservations. In regard to reservations, it is worth noting that Article 5 of the Vienna Convention on the Law of Treaties refers to any relevant rules of an international organization in relation to treaties adopted within it.